The framers of the Constitution did not originally include a Bill of Rights. They figured it wasn't needed. After all, the federal government wouldn't be strong enough to do much damage. And there was already language in the various state constitutions protecting individual rights. Plus, if you included some rights in a special list, didn't that mean that any that weren't included could be more readily violated? But not everyone was willing to take the weaknesses, and certainly not the benevolence, of the federal government on faith. Patrick Henry, for example, argued that the necessity of a Bill of Rights was greater in this government than ever it was in any government before. Without one, he warned, Congress will assume rather than give up powers. So in the end, a sort of informal trade was arranged. If states like Virginia and New York that were closely divided over ratification of the Constitution would vote to approve it, a Bill of Rights would quickly be added. In the first Congress in 1789, James Madison took on the task of drafting what were originally 12 proposed amendments sent out to the states for consideration. 10 of them, of course, became the first 10 amendments to the Constitution in 1791. It's worth reminding ourselves of what they include. The First Amendment addresses religious freedoms and the freedom of speech and the press, as well as the right to public assembly. The second deals with the right to bear arms. Now those are in the news all the time, but how about the Third Amendment? It reflects a particular complaint the American colonists had about the British government, the quartering of troops in private homes. The next amendments then deal with criminal procedure. The fourth protects against unreasonable searches and seizures. The fifth against the deprivation of life, liberty, or property without due process of law. It also says you don't have to testify against yourself in a criminal case. That's why you take the fifth if you exercise your right to remain silent. All told, the Fifth to the Eighth Amendments protect you against excessive bail or fines, as well as cruel and unusual punishments. They make sure you can't be tried twice for the same crime. They guarantee you'll get a speedy trial by an impartial jury while represented by an attorney, and they promise that if the government takes your property, you have to get paid for it. The Ninth Amendment then tries to solve the problem I noted earlier by providing that the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And the 10th Amendment, which we talked about in Episode 2, holds that the powers not given to the United States government by the Constitution remain with the states or with the American people. The very purpose of a Bill of Rights was to withdraw certain subjects from political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. So said Supreme Court Justice Robert Jackson in 1943. That sounds clear, except that the Bill of Rights is rife with political controversy, and different courts frequently make different decisions about what terms like reasonable or cruel and unusual mean in practice, and about the legal principles involved. After all, the First Amendment starts by saying Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech and so on. But the courts have held that no law actually means not too many laws. We'll come back to that in a moment. But first, go back a few words in that sentence. Congress shall make no law. Originally then, the Bill of Rights only applied to the federal government, Congress. Could a state establish a religion or search unreasonably? Sure thing. In 1833, the Supreme Court heard a case called Barron v. Baltimore. The city of Baltimore had taken a wharf owned by John Barron without what he considered just compensation. They gave him exactly nothing. Barron sued, citing the Fifth Amendment, and the Supreme Court responded, "Too bad, no cash for you." The court ruled that if the state of Maryland didn't protect its citizens against such seizures, he was out of luck. The Bill of Rights would only have protected him if it had been the United States government itself which had taken his property. But these days, the Supreme Court would have no problem ruling in favor of Mr. Barron. In fact, it does so all the time. So what happened in between? One key change is the 14th Amendment, which was ratified in 1868 after the Civil War. Before that, people were first considered citizens of their states and then of the national government. But the 14th Amendment specifies that all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside, and ensures the equal protection of the laws. States can't abridge the privileges or immunities of citizens of the United States, nor can they deprive any person of life, liberty, or property without due process of law, language which overlaps with the Fifth Amendment's guarantee of that same due process. Over time, the Supreme Court decided these provisions meant that the Bill of Rights applied not only to the federal government, but to states as well. After all, if state residents were U.S. citizens, and states could not abridge the rights of those citizens, the Bill of Rights made sense as a way to define what states could and couldn't do. The bulk of cases extending the Bill of Rights to the states, a process called incorporation, took place from the late 1920s to the late 1960s. But you can find such cases as early as 1897 and as late as 2010. The Second Amendment, for example, was one of the later additions. Until the early 21st century, the court had not found an individual right to bear arms that limited the state's ability to regulate guns. All this proves complex. We could give each amendment its own series, playing out its political and legal interpretations across the sweep of American history. Write in, tell Bowdoin you want just that. But in the meantime, let's think about the kinds of issues that arise in just a couple of areas. We can start at the top with that injunction that Congress make no law abridging the freedom of speech. There have been Supreme Court justices who have read that literally and opposed any and all limitations on speech. But most have not drawn the line so firmly. What about obscenity? Can I say anything I want, anytime and anywhere? What about libel? What about commercial speech? Can companies tell straight-out lies about their products? And did you know that for every episode of Founding Principles you watch, you get $20 richer and 10 pounds thinner? As you might guess, defining all these terms is itself contentious. When does exaggeration become actionable untruth? One person's piece of art is another's dirty picture. In fact, one justice said that the best definition of obscenity he could come up with was, "I know it when I see it." What about wartime? Do you know that when you see it? Defining the freedom of speech that is consistent with national security is yet another tricky issue. In 1798, the Sedition Act went so far as to make it a crime to write, print, utter, or publish any false, scandalous, or malicious writings against the government of the United States with intent to defame. Now that would make most of the internet illegal. That act didn't survive for long, and rightly so, but there was another Sedition Act passed during World War I, and plenty of censorship during other wars, both hot and cold. Justice Oliver Wendell Holmes wrote in 1919 that the character of every act depends upon the circumstances in which it is done. After all, he said, you shouldn't be allowed to falsely shout "fire" in a crowded theater and cause a panic. Thus, the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Holmes had a pretty high bar for his clear and present danger test. But when after World War II, Congress passed a law restricting freedom of assembly by banning membership in the Communist Party, the Supreme Court said that was fine. Being a member of that party might not lead to immediate action, but in each case, the courts must ask whether the gravity of the evil, discounted by its improbability, justifies such invasion of free speech as is necessary to avoid the danger. We might call this a clear and probable danger standard. The outcome of any given speech might not be likely, but if it did happen, it would be horrific. So the speech could be banned, just to be safe. Over time, though, the court has been more open to free expression, even when it is offensive, and especially to political speech about ongoing events or public officials. There may be limits on the timing and location of such speech, but generally not on its content. Holmes's standard seems to have taken hold. Does the speech in question so imminently threaten immediate interference with the lawful and pressing purposes of the law that an immediate check is required to save the country? As the court put it in the 1960s, we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, sometimes unpleasantly sharp attacks on government and public officials. Sometimes questions arise about other liberties not mentioned directly in the Constitution. How about a right to contract, to sell your labor? Back in the early 20th century, opponents of laws that limited work hours or required a minimum wage argued that these laws unfairly constrained workers' rights. In the 1905 case, Lochner v. New York, the Supreme Court agreed, saying that the general right of an individual to be free in his person and in his power to contract his own labor was one of the liberties protected in the 14th Amendment. Lochner was a baker, and New York law prevented him from working more than 60 hours per week. The court held that bakers are smart people, and thus are able to assert their rights and care for themselves without the protecting arm of the state interfering with their independence of judgment and of action. The court reversed itself during the New Deal, allowing for more expansive state action with regard to working conditions. In either direction, the key was really not the intelligence of bakers, but the role of government in the economy. Okay, what about another version of this? Is there a right to privacy? That's not specified in the constitutional text either. But there are amendments where privacy is implicitly defended. The right to remain silent, for instance, might imply a right to personal autonomy. And your home can be searched only if the government gets a warrant to do so. Perhaps the right to privacy exists in the shadows cast by these other amendments. When this argument has centered on questions of reproductive rights and private relationships, the courts have decided that this is indeed the case. Laws barring access to contraception were struck down in the 1960s. And the court found in its 1973 Roe v. Wade decision that the right of privacy, whether it be founded in the 14th Amendment's concept of liberty or in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. That, of course, remains a controversial decision many decades later. But the very nature of the kinds of arguments that arise under the Bill of Rights guarantee they will not be settled anytime soon. There are lots of questions left hanging. Just a few. Is it better to release a guilty person because of too much due process, or to convict an innocent one because of too little? When does national security override personal freedom? Is it okay to watch over or read the communications of people who haven't done anything yet, in case they do? History suggests that all these questions must be answered in specific ways that rely on specific circumstances, and that the answers will vary over time.
Given the complicated balance between an individual's rights and a society's needs, between liberty and security, we'll probably be debating the Bill of Rights for as long as we have one to debate. The same is true when we turn to thinking about civil rights, to questions of equality and how we define the equal protection of the law. Tune in next time, and we'll do just that.